Officer, I'm going to ask the question again. Before today's trial, did you have the opportunity to review the defendant's certified driving record?
Yes.
Okay, would you recognize a copy of that if I showed it to you here today?
Yes.
For the record, I'm showing both the defense and the witness what's been pre-identified as State's Exhibit 2.
We're still objecting.
And now handing the witness. Officer, do you recognize what's been pre-identified as State's Exhibit 2?
Yes.
And can you tell us what this is?
This is an official driving record of Mr. Calvin Augusta Riley.
And where was this produced from?
The Florida Highway Safety and Motor Vehicles.
Now, I want to direct your attention to the last page. Could you tell us what this last page is discussing?
Yes.
Objection, hearsay.
This is for foundation purposes. It's the certification from the custodian. So it's for foundation purposes, and therefore it's not being offered for the truth.
And still objection, she's not the custodian of record.
Officer, I'm going to proceed with the questioning. Could you please clarify what is the last page of this document?
It says that it is a true and correct transcript of the above named subject's driving record.
Is this produced by the custodian of the record?
Yes.
Objection.
Grounds for objection?
She has no personal knowledge of that.
She's reviewed this document in advance. It's a business record. It has a custodian attached document. The rules of evidence do not require that the actual custodian comes in person if there is an attached certification and affidavit from the individual. Therefore, she would have personal knowledge because she has reviewed this previously.
There has not been a notice to the defense. Is it also your assertion that this is not hearsay because it doesn't actually go to the truth of the matter asserted?
The truth of the matter, this is being offered to show. This isn't being offered for the truth of the matter asserted. This is purely for foundation purposes to establish that this is a custodian affidavit, and that is purely what it's being offered for. That is not hearsay. It's for foundation purposes. It is standard to ask that question for laying the foundation in a hearsay, for anything that is hearsay related to a regularly conducted business activity, and therefore we will proceed with questioning, and the objection is noted for the record. Officer, I'll ask the question again. Could you please clarify what this last page is again?
Yes. It says it is a true and correct transcript of the above named subject's driving record.
Is this produced, or is this an affidavit from the custodian of that record?
Yes.
Okay. Now, officer, I also want to ask some additional questions. The information that is in this document, did you have access to this information before reviewing this document?
Yes.
Can you tell us where you had access to it?
In the law enforcement database that I used.
Is that law enforcement database known as David?
Yes.
And what specifically do you usually use David for?
So David is a database that has driver's license information as well as driving history, and it's used for identification purposes.
Okay. So, officer, is this the information you had access to on the night that you were investigating the defendant
Some of this, yes.
And did you review this information that evening too?
Yes.
Okay. The state moves to enter what's been pre-marked as State's Exhibit 2 into evidence as State's Exhibit 2.
Objection.
It's noted for the record. Additionally, I don't know if I entered it earlier just for purposes. The state also moves. Did we move to enter the body worn?
Yes.
Yes. Okay. Cool.
And just for clarification, that's with the edits per judge's orders?
I'm sorry.
Is that already with the edits per judge's orders?
We weren't. What? If this has edits. With the
Per judge's orders.
Oh, I don't think that one has been edited.
Then we'll need a properly edited one
Yeah,
pursuant judge's
sure.
orders.
That's fine. We'll plan on doing that. Okay. Okay, officer, I want to direct your attention to page 1. Who is this document listed for?
Calvin Augusta Riley.
And I want to direct your attention to the header that states residential address. What does the residential address say for the defendant?
429 West Brevard Street, Tallahassee, Florida, 32301.
Can you tell us what the significance of this address is to you?
That was the address provided by Mr. Riley that night.
Now I want to direct your attention to page 4. Pointing your direction to the last entry on page 4, can you tell us what that is?
It's a suspension.
And when did the suspension take place?
Objection, hearsay.
It's noted for the record, assuming that this has already been entered, it would not be hearsay once it's been entered and approved by the court.
Do you mind asking the question again?
Yes. Can you tell us when the suspension, which, to clarify, pointing your direction to the first column for the last entry, when was the suspension effective?
February 13th of 2023.
When did the defendant receive notice of that suspension?
January 27th of 2023.
Where would notice have been sent?
429 West Brevard Street.
Now I'd like to direct your attention to page 2. Can you tell us what the first entry is for? Or, sorry, page 5.
It is a suspension.
And when was that suspension effective?
March 13th of 2023.
When did the defendant receive notice of that suspension?
February 24th of 2023.
Where was this second suspension notice to?
429 West Brevard Street.
And to clarify, is that the defendant's address?
Yes.
Okay. Now, I would like to direct your attention to the third entry on page 5. Can you tell us what the third entry is?
A suspension.
When did that suspension take place?
It was effective March 22nd, 2023.
And when did the defendant receive notice of the third suspension?
March 7th of 2023.
And where was that notice sent to?
429 West Brevard Street.
Now, officer, referring to all three suspensions that we just discussed on, were all of those still effective or in effect when you stopped the defendant on May 7th, 2023?
Yes.
Did he, at that point, complete the requirements to satisfy the suspension according to the record?
No.
When did he complete the requirements?
May 26th of 2023.
And to clarify, how many days after the stop did that take place?
19.
Thank you.
May I see it for just a minute? Thank you.
Now, in transition to the second half of your investigation, after you look into your database and see the suspension, do you call any backup to the scene?
I do.
Who do you call?
Officer Muth.
And why did you call Officer Muth to the stand or to the scene?
Objection relevant.
It's relevant to not only the timeline of events, but also why Officer. If I could just have a moment. As it pertains to relevance, relevance is a low bar. It goes to whether or not a material fact is made more or less likely. Officer Margaret Muth is called to the scene to conduct the DUI investigation, which is an integral part of this case, and also directly goes to the element of whether or not the defendant was impaired. Therefore, it would be relevant under Rule 401. Officer, I'm going to ask the question again. Why did you call Officer Margaret Muth to the scene?
To help me conduct a DUI investigation and officer safety.
Why would you feel the need to call another officer for officer safety?
Objection relevance. It doesn't go to prove a material fact as to why she felt like she needed to be safe.
During the suppression hearing, or as a response for the record, during the suppression hearing, the defense asked questions about why the defendant specifically couldn't have his phone, why it took multiple people to escort him to the car. Based on that alone, this is relevant as it goes to why she behaved in a particular manner during their investigation, and a witness's credibility is always relevant in a proceeding.
Just as a response, I don't understand how this goes to witness credibility, and this is not the suppression hearing, this is trial, so I would argue that it is not relevant and does not go to any material fact, and none of those facts have been entered into evidence, so it should not be relevant, Your Honor, but you can go ahead and proceed with the question.
No objection, because based on your response, you're also suggesting that it's prejudicial with little to no probative value.
Officer, I'm going to move on. Okay. I'm going to move on. Was the defendant ultimately placed under arrest after Officer Muth came to the scene?
Yes.
And were you present during that arrest?
Yes.
Before the defendant was placed under arrest, did he make any statements about what he was doing that night?
Yes.
Can you tell us what those statements were?
He said that he had had 2 beers and smoked a little weed.
Okay. Now, I want to talk about the defendant's behavior after he's placed under arrest. Can you tell us, did you bring the defendant to a patrol vehicle after placing him under arrest?
Yes.
Can you tell us what his behavior was like as you were trying to bring him to that patrol vehicle?
He was obsessed with getting his phone, making a phone call, and closing his car door.
What was the tone of his voice during this conversation?
Panicked.
Did you ever offer... Okay, so you mentioned that the defendant seemed panicked when he was asking about his phone and having his car door shut. Did you ever offer to get his phone or anything of the sort for him in response?
Yes.
And specifically, why did you not obtain it in that moment?
For officer safety purposes.
And could you elaborate a little bit more as to what you mean by that?
Yes.
Objection relevance.
Officer, how many times did the defendant ask you to get the phone and shut his car door?
Multiple.
Objection relevance.
As it goes to relevance, this is relevant because it goes to his state of mind and his impairment level. Asking multiple times for something is a known indicator of impairment, and it therefore would go to that element of DUI.
He asked for it multiple times.
Is asking questions like that multiple times something you're trying to look for when trying to spot signs of impairment?
Yes.